Gailey. Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery. Today's Doug Austin. Important case law decisions for August 2022 with our faculty experts. Doug, of course, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel by the question mark there. This webinar will be recorded and available for replay at your convenience, as will all of our webinars. Please take a look at the Attachments tab, which is the little paperclip, for a link to subscribe to eDiscovery today. Also a link to Doug Austin's Getting a Clue About Project Management, a registration link for next month's case law webinar, and up next on EDRM, webinar channel, Microsoft Purview and ONA, Rethinking Data Collection from Microsoft. You'll see why that's important in a little bit. Learn more about Tom O'Connor and check out his Spicy Techno Gumbo blog. There's a link to Judge Peck and how to engage him, and a registration link, again, for next month's case law webinar. And last but without least, we have another EDRM rip from the headlines. On the 7th, The Mystery of the Mar-a-Lago Docks and the Special Master with the Honorable Kristen Mix and Dr. Bora Grossman. After the webinar, you can download a certificate of attendance from the top of the viewing screen on the console. And Doug Austin, he is the editor and founder of eDiscovery Today, our wonderful partner. Doug has over a decade of experience in the trenches of eDiscovery, posting at least once each business day, and most of the time, multiple times, since 2010. He earned JD Super's Reader's Choice Awards in cyber and eDiscovery. Tom O'Connor, hailing from the great city of New Orleans, for over 3 decades, he has stewarded the Gulf Coast Legal Technology Center and has a wonderful YouTube channel for long-form interviews. He's a sought-after consultant on some of the largest cases. And we have the Honorable Judge Andrew Peck, who retired as a federal magistrate judge in the Southern District of New York after 20 years, writing many of the opinions that the cases that we're covering today are based on. eDiscovery generally, keyword search terms, boilerplate objections, and I'm not forgetting the 502D orders. And of course, technology-assisted review. He's a graduate of Duke, now with DLA Piper. He advises on information management, particularly in the eDiscovery context, and acts as a mediator, arbitrator, and special master. We at EDRM are very, very grateful to these 3 gentlemen for serving on our advisory council. And with that, Doug, we got some cases to cover.
Indeed, we do, Mary. We have another quite unique group of cases this month. Our 6 cases involve disputes including waiver of marital communications privilege, custody and control of source code, third-party subpoena of a party's IT provider, and spoliation sanctions and deposition attendance. 2 of our case law rulings are deja vu all over again, as they're additional rulings on cases we previously discussed. We even have a disastrous handling of eDisclosure across the pond and a failure to preserve ESI, equine stored information. And just a reminder, and since we've already gotten a question on it, we will send a copy of the slides out after the presentation, so look for that. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. So speaking of deja vu all over again, there it is. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery Today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 24,300 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. You might think that I selected this first case for the puns, but I actually selected it because of real discovery issues. So I'll rein in my desire for puns, and I promise I won't beat a dead horse.
There's one.
There's two, actually.
That's two. Yeah.
There you go.
You're not going to settle
I
with
promise.
too many, are you?
As far as I'll go. Anyway, in this contract dispute, the plaintiff purchased a horse named Big Rig from the defendants. The plaintiff alleged that the defendants shipped Big Rig to Texas, and when the horse arrived, it wasn't suitable for competition. He also alleged that he negotiated a replacement agreement with defendant Stephen Temple, but the defendants refused to provide the plaintiff with a selection of potential replacement horses or refund his money, alleging that the horse returned from Texas lame and instead demanded that the plaintiff pay for Big Rig's medical bills. Early in the case, counsel for the plaintiff sent a pre-litigation letter to the defendants indicating his involvement in the case and noting defendants' duty to preserve evidence which you know or reasonably should know is relevant to this action. Still, the defendants reportedly either never responded to discovery requests or refused to respond to them, resulting in the plaintiff's motion for failure to preserve evidence and failure to provide the horse for inspection. In reviewing the case, Arizona Magistrate Judge Bruce McDonald noted, when asked if Big Rig was in good condition when he was returned to defendants and is in good condition now, why there was the current lawsuit for a return of plaintiff's purchase payment, defendant stated that Big Rig was returned damaged, but he admitted, however, that he did not keep any records of this treatment, which would have been more traditional ESI to preserve for this case. He also noted that plaintiff sought to inspect Big Rig to assess his condition and determine if he was currently sound and healthy, but sadly, it was subsequently disclosed that Big Rig died between July 4th and July 6th of 2021 in Arizona. As a result, Judge McDonald recommended that the district judge enter an order granting the plaintiff's motion for sanctions for failure to preserve evidence and failure to provide a horse for inspection, stating that an adverse inference jury instruction is appropriate, even though he also stated the record is not clear that defendants acted in bad faith. So, Tom, what do you think about the fact that Judge McDonald recommended an adverse inference sanction, even though he didn't find that the defendants acted in bad faith?
Well, I guess initially, that surprised me on his face. I thought, well, have to be bad faith. But Judge McDonald did a really detailed analysis here of what he called culpability, and cited Christopherson versus Molly, which was another federal case in Arizona, and which quoted the Rimkus case. I think we've talked about that before.
Oh, yeah.
Yeah, stating when a party is prejudiced but not irreparably from the loss of evidence that was destroyed with a high degree of culpability, a harsh but less extreme sanction than dismissal or default is to permit the fact finder to presume the destroyed evidence was prejudicial. And then he went into an analysis of culpability and what the factors are, and basically said courts have found that an adverse inference instruction may be warranted where the destruction of the evidence was either willful or grossly negligent. I presume he then felt that allowing the horse to die was one of those two, either willful or grossly negligent. And the preservation of the health of the horse to allow the inspection. It's an interesting case to read. His, as I said, very detailed analysis of what he called and what Rimkus called culpability.
Yeah, absolutely. And that's, so I really did pick it for discovery reasons. Judge Peck, since Rule 37E addresses failure to preserve electronically stored information, does it even apply when we're talking non-electronic evidence? And if not, what does?
Technically, no, Rule 3070 only applies to ESI. That was an intentional decision by the drafters because they were worried about applying it to physical evidence. You know, the tire that blows out and gets thrown away, but nevertheless, there is a lawsuit, you know, that the tires blow up, cause the car to hit the tree, or, you know, whatever it may be. So 3070 only on its face applies to ESI. There are some decisions that apply it to paper and to video in the situation where it's unclear whether the video is old-fashioned video or electronically stored video evidence. Never saw it applied to a horse and probably never will. And when 3070 doesn't apply, then you go back to each circuit's pre-ESI case law, common law on spoliation, most of which require, all of which require a degree of fault, and most of which require bad faith or similar willfulness type language in order for there to be a sanction under the common
Interesting, because I was curious what you were going to say, because I didn't honestly know how that would be addressed. So that's very interesting. So, Mary, I'm certainly, this is not the, while we usually cover cases related to electronic evidence, we have covered other cases in the past, I mean, cars and things of that nature. So what recommendations do you have for our audience when it comes to handling non-electronic evidence in discovery?
Well, first I want to say this poor horse is more than a non-electric thing.
Right.
I mean, my goodness. But having said that, I was interested to hear about the analog versions of video as opposed to the digitized versions on video. That raises things like wet signatures on paper. Mm-hmm. And things like that. But for other things, consider the importance of those things. For example, as Judge Peck said, the defective tire. That's what came to my mind when I first read this case. Or maybe a pharma lab notebook that has the scientist's handwriting. Those are really important things. And then just like we talk about cross-border, it's good to have somebody on the ground in country. It's good to have somebody on ground in the area of expertise with those things, like train accidents, malpractice, the product's liability. And you have to consider expenses for storing and maintaining that physical evidence, or to have something, some kind of an agreement. If whatever that thing is normally degrades, what kind of obligation do you have to, keep it going, or to extract from it, or to do something like that? And so that'd be, as this ESI person would say, that's what I've got for you, Doug.
Yeah, well, that makes perfect sense, and are certainly great points. And yeah, we don't cover too many cases that are not involving electronic evidence, but this one was interesting because it did, and also because of how the judge ruled, which I thought was fascinating. So we'll move on to the next case, which is is the first of two decisions involving cases we've covered before. This one is the never-ending DR Distributors case involving Illinois District Judge Ian Johnston. This time, the defendants had 3 productions where there were disclosures of communications between the owner of 21st Century Smoking, Brent Duke, and his wife, Lori Duke. Based on these disclosures, the plaintiff filed a motion for the communications to be waived. The defendants opposed the motion and sought to claw back the documents, relying on Federal Rule of Evidence 502 and the fact that the court on its own entered a Rule 502D order as the proper standard to be applied to protect waiver of privilege. After a detailed review of the communications, which illustrated that the court is not the only entity that has disdain for Brent Duke, Judge Johnston first addressed the application of Rule 502 to the waiver of privilege for the documents in question, stating, apparently, according to defendants, the court wears the jacket, at least partially, for their inadvertent disclosure. But the court refuses to accept any blame for defendants' failures. Judge Johnson also added, the chutzpah of defendants' argument is almost too much to take. But it became a moot point when Judge Johnson noted, as the plain language of Rule 502 makes clear, the rule only applies to the attorney-client privilege and the work product doctrine. He also noted that for some of the documents defendants seek to claw back, the court's order had no causal effect as they had already been produced before the order. Judge Johnston also referenced our own Judge Peck, who stated that a Rule 502D order can be viewed as a get-out-of-jail-free card, but noted at least some courts have found it still has limits. Other courts have found that, despite the existence of a Rule 502D protective order, a completely reckless disclosure can result in waiver. Ultimately, Judge Johnston applied a three-part balancing test of whether the document was privileged, inadvertently produced, and whether privilege was waived, and found a waiver of the marital communications privilege, and that the defendants can't claw back the documents. But he also stated a finding of subject matter waiver does not necessarily follow, and also defendants have not waived any objection as to admissibility. So Judge Peck, in addition to citing your comments about 502D, Judge Johnston also cites the SureFit Home Products case, which we discussed a couple of months ago, as an example where a 502D order didn't protect against waiver. I didn't find a mention of a 502D order in that ruling, but do you think there is a scenario where a completely reckless disclosure can result in waiver even with a 502D order?
First of all, you can't tell from the decision in SureFit from my former colleague, Judge Gorenstein. He refers to the party's protective order or whatever, but I went back and looked at the letter briefing on that case, which says that there was indeed a 502D order in SureFit. Sort of a stealth thing in SureFit. But I guess the answer is, better to have a 502D order than not. But if you are completely reckless, even with a 502D order, bad facts can make bad law. You risk that a judge, as Judge Gorenstein did in SureFit, is going to find a waiver. So get your 502D order. I really appreciate that Ian Johnston has been listening to me enough that he sua sponte gave them the 502D order, but you still can't be a horse's rear end in how you deal with it.
Oh, that's the horse of a different color.
I got another one.
Right back. So Mary, if 502D doesn't apply to the marital communications privilege, what is the best way to protect against waiver of inadvertent disclosure of marital communications?
Well, first of all, know your custodians. Are they married? That would be a good
right.
That would be a good one. And then the other thing to do is to normalize the names. So nicknames, all the emails, the screen names, the canonical names, so that you can have the communications between the two presumptively privileged. And that's an easy sort of a categorical privilege log if you can negotiate that with the other side. So that would be one thing. Definitely negotiate a good clawback with protocols that you yourself can adhere to, and review those protocols with the review team, the team that are actually looking for privileged documents to include the marital privilege, because I would gather that's not included in a lot of the trainings for review teams on privilege.
Absolutely. I think this is one of the first cases I've seen that involved marital communications privilege. So yeah, absolutely. That's a great point. And some great tips for really finding those documents and making sure you're protecting them up front. Yeah.
And just a note on that. one has to know the case
Yeah.
law
Mm-hmm.
in your
Mm-hmm.
jurisdiction. As Judge Johnston noted, in many jurisdictions, the business exception to the marital privilege would make it not privileged. In other words, if the husband and wife, as was the case in 21st century smoking, were working together, that might not, in many courts, be covered.
That's
by
right.
marital
Yeah,
privilege.
I had forgotten that, but yeah, absolutely. That's a great point.
Very good point.
Yeah. So, Tom, why do you think Judge Johnson refused to allow clawback of the marital communications, but still chose not to find waivers of subject matter or admissibility?
Well, it seemed like, and from what I'm hearing the judge and Mary say, we're talking about two different things here. The claw, that's one discussion. And then, and as the judge himself said, just because they can't claw back the documents doesn't mean there's an automatic finding of subject matter waiver or waiver of admissibility. And he had to look at those as separate instances and decide the three-part balancing test as to whether there had been a waiver. So I think it's apples and oranges.
Okay. Yeah, fair enough. Obviously, I guess there probably leads to maybe disputes down the road if they do choose to try to admit evidence, some of those communications. But it seems like this is a case that will never end. So it's just one more dispute to look forward to. So, all right, we will move on to our next case, which is a patent dispute over technology that alerts users when a child may have been forgotten in a car seat, which, by the way, why isn't that already required for all car seats? I wish it was. Anyway, here, the plaintiff claimed that after disclosing sensitive technical information about their technology's design and function to the defendant broke off contact and then released a product of its own called SensorSafe, despite being aware of the plaintiff's then pending patent applications. Most of the discovery disagreements revolved around these issues: the latest iteration of the defendant's SensorSafe system and the defendant's relationships with two third-party companies, SWG and Cookie Lab, which were partners to develop the SensorSafe products and a mobile phone application, respectively. There were several specific topics of dispute associated with the plaintiff's motion to compel, which included source code in the possession of SWG and Cookie Lab and custody of that source code. Regarding the dispute over SensorSafe 3.0, Arkansas District Judge P.K. Holmes stated, "The court has reviewed both R&R's complaint and its initial infringement contentions regarding the 943 patent. Neither of these documents limits R&R's accusations to a particular product version. The objection that SensorSafe 3.0 is not an accused product is not a valid basis for even flow to withhold production of materials that are otherwise responsive to R&R's discovery requests." Finding that source code custody and control is the defendant's responsibility, Judge Holmes stated, "The court has already found above that SWG's and Cookie Lab's SensorSafe materials are within evenflow's control for purposes of Rule 34. To whatever extent evenflow does not understand SensorSafe source code sufficiently well to discern which portions are relevant to R&R's infringement allegations, then it is evenflow's obligation either to acquire a sufficient understanding of its own product to identify and produce responsive materials, or else to instruct persons at SWG and Cookie Lab who already possess such knowledge to identify and produce the responsive materials." As a result, Judge Holmes granted the motion to compel on the source code. So, Mary, it seems like we're seeing a lot more cases involving discovery of source code. Do you agree? And if so, why do you think that is?
Oh, I certainly do agree, Doug. I also see a trend, an emerging trend towards data sets or source data being even more important than the code. But let's stay on the code part right now. It's important to know that most eDiscovery software is configured or hard-coded itself to exclude source code, like your Javas or pure text or EXEs that you find. They sometimes called system files, and then the source code that generates those those system files or configuration files. So if you have an IP matter that depends on source code, you certainly need to know to turn those things off. And then when you have trade secret theft, there are ways to read source code to see if there has been some reverse engineering. Sometimes there's just a new layer put on basically the same code that's run through basically a translator situation where it moves that code into a different source code language, but it's essentially the same code. And you wouldn't be able to tell that unless you looked deeply at it.
Yeah, absolutely. And so, yeah, it really becomes a lot involved, and you have to certainly know, these are some great points of knowing what to consider when it comes to requesting source code and exactly what you're going to get there. So technical expertise in that is key. So great points, Mary. So Tom, Judge Holmes noted that Evenflow has not made any concrete showing as to the time or expense that would be involved in producing censor-safe source code. In other words, they didn't really provide any information to justify their burdensome kind of objection. Did they drop the ball here, or would it not have mattered, considering this was an IP case and they probably would have had to produce it anyway?
No, I think it mattered. I think the judge said in a clause just before where you picked up at the word Evenflow, quote, to the extent that Evenflow's objection is one of proportionality or undue burden, the court rejects this argument because Evenflow has not made any concrete showing. The dispute point was about proportionality. Therefore, it's clear that they had to make some sort of showing about time or expense to justify such an argument, and they did not. So I think he was focusing in on that.
Yeah, absolutely. Certainly that's what he stated, and it certainly seems like that could have been an objection they could have beefed up or addressed more. So
yes.
So Judge Peck, regarding custody and control, isn't source code developed by a third party for a company always considered to be in the control of that company for discovery purposes, or do the specific facts of this case dictate that it is in Evenflow's control?
Well, I think you always have to look at the specific facts of a case. And usually we see this, concept of work for hire in the entertainment industry, where motion picture scripts are written by somebody, but the copyright, since it's a work for hire, is owned by the producer or the motion picture studio or the like. So almost always when you have real work for hire, it does become the property and owned by the company, regardless of who created it. But, regardless of whether using the legal right or practical ability test, it's certainly in Evenflow's possession, custody, or control here. So to me, Judge Holmes' decision that it was within their possession, custody, or control was an elementary decision.
All right. Very good. So a couple of comments and questions. Technical expertise is key. I like that tip. Thank you very much. Also a question, are there any best practices regarding production of source code to protect the intellectual property, like protective orders? What's typically done in these cases? Anybody have?
I actually testified as an expert witness on this in a state court action. And there are some well-recognized procedures. Usually the source code is put on an air-gapped computer, meaning no ability to print from it, no outside access. And then the expert for the opposing side comes in and looks at it, and there are restrictions on what notes can be taken and all sorts of related things. So generally, it doesn't go to the lawyers because they're not going to understand it. It certainly doesn't go to the opposing client. It goes to an expert under very strict, sort of like, skiffs for looking at government secrets.
Yeah, well, that makes perfect sense, and a great question, and thanks for a really informative answer there, Judge Peck. So we will move on to our next case, which is a case alleging violation of the Equal Pay Act by paying disparate benefits and wages to the plaintiff while he served the defendant as both police chief and city administrator. Here, the plaintiff served a notice of intent to issue a subpoena just 1 week prior to the close of discovery to have defendant's IT vendor, actually, I think former IT vendor, Net Standard, run searches on city email data that might still be housed on their servers and produce all responsive emails. The defendants objected, arguing the subpoena was issued in violation of FRCP Rule 45A4 because they claimed they were not provided notice of the subpoena before it was served, and they also argued that the plaintiff attempted to use the subpoena to avoid compliance with Fed Rules 26 and 34 after failing to obtain documents when he served his sixth request for production too late. After finding that defendants had standing to oppose the subpoena, Kansas Magistrate Judge Gwen Berzer stated, while the court would certainly encourage parties to give more than half a day's notice, courts in the circuit, her typo not mine, have found less notice to be sufficient. So she refused to quash the subpoena on that basis. But she stated the court is uncomfortable with plaintiff's tactic of going around defendants to their former IT vendor to conduct searches on any of the city's email data it may still have in its possession after its services were terminated. The court questions whether Net Standard would be permitted to divulge the contents of the city's communications under the Stored Communications Act without the city's consent. For these reasons, the court will quash plaintiff's subpoena, both the original and amended, to Net Standard. However, noting that it troubles the court that documents continue to come to light are presumably responsive to requests for production plaintiff has already served but have not been produced by defendants, and that defendants have known there were issues with the images of the city and police department servers and of plaintiff's computer created by Net Standard, but the parties and the court have seemingly never gotten to the bottom of the issues. Judge Berzer ordered the parties to cooperate and share the expense to have a digital forensic or eDiscovery vendor run the searches set out in the subpoena to Net Standard. So, Tom, does the plaintiff's subpoena on the defendant's IT provider prove that you can't always get what you want, but if you try sometimes, you get what you need?
Well, I was actually reminded musically of the great 1973 song by local New Orleans legend John, who said he was in the right place, but it must have been the wrong time.
There you go. That's another good one. Yes.
He can't, I mean, I don't know. They must have just kind of shook their heads and say, well, thank you to the great spirit in the sky or whatever, because the judge quashes the subpoena and then orders them to run searches, shared expense by a forensics expert for all the same terms that were in the subpoena. So I guess, yeah, right place, wrong time.
Yeah. Got it. The plaintiff got what it wanted, maybe one way or another.
Yeah.
Obviously, we'll see. So yes. Give them credit for finding another way. So Judge Peck, do you think Judge Berzer was correct in ruling to quash the plaintiff's subpoena, given the defendant's discovery omissions and shortcomings?
I do. Discovery shortcomings can be a reason to allow a non-party subpoena as opposed to getting the documents only from the opposing party. And I suggest those interested in this whole issue of Rule 45 read the Sedona commentary on use of Rule 45. And that's one of the things we talk about. When can you go to a non-party instead of the party. Here, two factors overrode the defendant's non-compliance or reluctant compliance. One, I mean, this is clearly this is clearly the city's information. It is not like the city had communications with Net Standard and you couldn't get the city side of it, so you go to Net Standard for those communications. This is one. Whether this is really a Stored Communications Act case or not, I'm somewhat dubious, but it's clearly the city's data. Secondly, and perhaps, on a practical basis, most important, as I read this decision, Net Standard downloaded all of that information onto a drive and provided that to the parties. So the only question then was running the searches against that drive, and the court ordered the parties to cooperate. Ordering cooperation doesn't necessarily get cooperation, but, so it seems to me that was a reasonable way to deal with this situation.
Great point leads to my question for Mary. Mary, do you think Judge Berzer's order for the parties to cooperate on the proposed searches will address the issue, given that the parties have failed to fully cooperate on discovery thus far?
I think that depends on how deep the pockets are and how much one or the other party wants to delay. Because once the searches are run, what about privileged material? What about non-relevant material? They can still argue, but because they have to share the expenses, that might, lean towards cooperation, but you just don't know. And whoever the vendor or the forensic expert is, they should have some really tight bounds and a lot of power to get things done.
Yeah, absolutely. And obviously that'll be key here because, and we'll cover another case here in a few moments regarding getting to data when there's issues, when the producing party says there's issues getting to the data. It will be interesting to see if we have additional case law on this with regards to that. So certainly an interesting one, and certainly an interesting workaround that the plaintiff managed to find in this instance, at least. So we will move on to our next case, which is our second ruling involving a case we've discussed before, which is the inadvertent spill of 3 million gallons of wastewater by an EPA-led contractor crew in the inactive Gold King mine that polluted rivers all over. This time, we're dealing with a case where plaintiff state of Utah sought documents related to the work that defendant Harrison Western Construction Corporation performed or planned to perform at the Gold King mine in 2014 and 2015. But Harrison produced limited documents before and after the spill, stating its third-party IT consultant suspected that a catastrophic event, talking about issues again, occurred at some time prior to the migration of information and data from the prior server to the new server, resulting in information and data that was corrupted and inaccessible. Later on, when Harrison's Rule 30b-6 representative was deposed, and also the Harrison employee with the most information on the Gold King mine project was deposed, no attorney for the state of Utah appeared at or attended either deposition. New Mexico District Judge William Johnson stated, "There is no dispute that Harrison knew or should have known that litigation was imminent," adding, "Harrison failed to take reasonable steps to preserve its ESI. Other than implementing a litigation hold, Harrison does not identify any other steps it took to preserve its ESI, to ensure that the relevant ESI would be preserved." He also found that Utah was prejudiced by the data spoliation. But he also stated, "The court is, however, not persuaded by Utah's assertion that none of these documents can be replaced," also noting, while Utah contends that Harrison's explanation is implausible, Utah did not appear at or attend the depositions of Harrison's Rule 36 witness and Harrison's employee with the most information on the Gold King mine project. Witnesses who may have been able to address Utah's concerns about the implausibility of Harrison's explanation regarding the loss of the ESI. So Judge Johnson granted Utah's request for an order permitting Utah to introduce evidence of the spoliation at trial and reasonable attorney's fees and costs, but denied Utah's request for an adverse inference instruction. So Judge Peck, should a party's failure to attend depositions affect the severity of the sanctions awarded, even in a complex case like this?
Well, normally it probably wouldn't. But in this case, and there's a lot we don't know about, and presumably some of that would have been discovered if Utah had gone to the depositions and asked the Harrison folks some questions. So why is Harrison's explanation implausible? We don't know that from reading this opinion. And we don't know a lot of the facts, and certainly Judge Johnson didn't, that Utah could have developed as a result if it had gone to those depositions. So Utah had the burden to show intent to deprive. It didn't meet that burden. It didn't meet it in part because it didn't go to the deposition. In most cases, that probably would not be a factor.
Yeah, indeed. And certainly Judge Johnson made notation of that as a reason for not more severe sanctions. So Mary, issues during migrations seem to be cited regularly recently as a failure to preserve ESI. You discussed that, or another example of that on a recent podcast involving the Secret Service tax. There was a migration there. So is this a legitimate reason for avoiding sanctions, or is it a dog ate my homework type of excuse?
Interesting that you asked, Doug. So I think, as Judge Peck said, they didn't prove intent to deprive. So is the intent to deprive more important than the business decision on a migration? I mean, that's certainly an issue. And if you've got a case that goes longer than 3 years, you can pretty much guarantee there's some form of migration in there. But all the migration protocols and change management and everything else should have some form of a legal hold preservation capability in a granular way. Not like you have to put the whole dang thing on hold, but by individual, by department, by location, by dates. And when I used to work in enterprise IT, it was a common practice to take a snapshot before you migrated, throw the tape in a drawer, and then after migration, after you made sure everything was okay, you could get rid of that tape. But it was sort of an extraordinary backup that went on before the migration. It wasn't necessarily for preservation; it was for business continuity. And so there is a little bit of some parsing on that. And I would also add, there's a big, big difference between civil, criminal, and regulatory when you're talking migrations and destroying evidence.
Yeah, absolutely. And I'm not sure in this case where it's clear if this migration and the preservation aspect of it occurred during the case, because this case has been going on for a while, as you mentioned. And when a case goes on long enough, you might likely have a migration at some point. So it does kind of give you it does give you extra things to consider, for sure. So Tom, this clearly is a complex litigation. When we covered the previous ruling, it was a completely different set of parties. So there are a lot of parties involved, and you've worked on complex litigations involving numerous parties. So what recommendations do you have for our audience to manage the workload associated with discovery, including depositions from the various parties?
Yeah, this one's kind of a head scratcher to me. Every complex case I've been involved with, a team, a firm, maybe a group of attorneys within a specific firm is assigned different responsibilities. You're the depo team, you're the interrogatory team, you're the team dealing with the expert witnesses, You're the team handling the production of the ESI, whatever. There's a clear delineation of responsibility and who's going to do what and why. And there doesn't seem to be any indication in the opinion that I read as to why they didn't go to the deposition, except that the judge does say, quote, despite the opportunity to do so, Utah declined to attend or question Harrison Western's 30B6 rep about the loss of emails, even though the deposition took place 11 months after Utah became aware of the lost emails. I can't tell if what he's saying is they declined, like they affirmatively declined, like, thanks, we don't want to go. Like, we think we've got that covered. We've got all the evidence we need. Or they somehow tried to say, although I can't tell if there was a pleading to this effect, that they, it was slipped on them without adequate notice. And he was saying, well, it took place 11 months after you knew about the lost email. So you had plenty of time to prep for the depot. So I'm just puzzled as to why they would not attend the depot. And if it was in fact just a slip, somebody dropped the ball, again, that would be taken care of by a clear assessment of responsibilities amongst the team within the complex litigation of who's doing what. And then the depot team would be circulating, here's a list of all the depots, and we're asking these people to attend. If you can't, let us know, yada, yada, yada. So it's unclear to me what happened here and whether it was intentional.
Sure. But yeah, you make a great point about having a depot team that's their responsibility in a complex case like this. And obviously they didn't, whether they declined actively or just simply somehow wound up not being there. They did it not just once, but twice. So that's obviously.
Yeah, that's again, that strikes you out. If they did it once and it was unintentional, you'd think they would have been there the second time, right?
Right, exactly. So yeah, seems like they dropped the ball here, and it may have cost them, greater sanctions. So yeah, absolutely, great point. Question from the audience: does that mean migration of data needs special attention, tracking, and/or ? Well, certainly, Mary, you mentioned the idea of making that backup and putting it in a drawer and so forth. Any other recommendations any of you all have when it comes to migration of data to ensure that you've got what you've successfully migrated it before you move on?
Yeah, and I might say the desk drawer thing is an old school. With nearline backups and things like that, you can just send it somewhere else for a while and then bring it back. But I think documentation is critically important in the case notes. That's something that you did because it affects so many custodians, and if not all of them. And without those notes on what date the migration occurred, that you wouldn't be able to defend yourself. And then I would also probably encourage some voluminous logging and putting those logs away as well for when you need them.
Like Mary, I've done a few of those, or I did a few of those back in the day. Two other things I'd suggest: you make sure you give yourself plenty of time to do that migration in a low impact time, like a weekend or a holiday, and then try to verify it against that backup that you made. Make sure it went okay, especially if there's a lot of data. You want to make sure that you did in fact get everything over in the manner in which you need it.
Yeah, absolutely. And there's some different ways to do that. Obviously, you can do everything from a bit by bit verification to having the custodians make sure that all their stuff is there and so forth. So absolutely, it seems that we're seeing plenty of instances where there seem to be migration issues cited as why evidence goes away. It certainly seems like a very preventable problem. So we will move on to our last case, which is so out there, it's not even from this country. It's actually an e-disclosure case from the UK and the biggest e-discovery disaster in the past couple of months, not involving Alex Jones. Indeed. and then speaking of ripped from the headlines, this one involves alleged anti-competitive actions by the defendant against the plaintiff, which was a UK toy startup, which claimed the defendant's actions put it out of business. And in the case, the defendant had several technical failures, which included the use of Microsoft Outlook software to conduct search and collection, the inappropriate use of Microsoft 365, which quote unquote also appears to have limitations when it comes to searching data, which is something we'll talk about in tomorrow's EDRM webinar with Ona. I'll be part of that. The failure to follow guidance from Microsoft as to how to conduct date range searches in mailbox held in Microsoft 365, a failure which led to the creation date field being used instead of the sent or received dates, which was described as a rookie error. Gee, you think? And they included a failure to exercise appropriate levels of quality assurance and control, including inadequate supervision by defendant's counsel and provider. As a result, approximately 40% of documents were missed, for a total of something in the region of 800,000 total documents having been missed. That delayed the trial over 2 years. From it was supposed to have started back in this past June, and now it's scheduled to start in October of 2024. And the mistakes, the defendant's mistakes, cost the defendants as a sanction over 578,000 British pounds in plaintiff costs. Now that's a disaster. So Mary, the ruling referred to the inappropriate use of Microsoft 365 because it appears to have limitations when it comes to searching data. To what level should an organization with M365 rely on it for conducting eDiscovery searches?
Well, Microsoft 365 is not your grandfather's Outlook. They have upgraded every year. It used to be that they didn't index PDFs, the graphical PDFs, which could be, all the contracts and things like that. They index a lot of things, but they have a lot of versions. And the versions that you pay more for have more capabilities. And then there was an indexing error when harvesting former employees' emails. And that's an interesting notice as well. How do they offboard? Where do those go? There were errors in larger data sets, and that's a problem. And that there was no audit trail at the time, so that they were unable to explain why the data was incomplete. The other thing they didn't do is they didn't include the unindexed items. So that's like an exception report.
Right.
When they ran the exports, and then this Microsoft Purview eDiscovery Premium. So it says that the tool offers the capabilities of Purview eDiscovery Standard, but with added capabilities, and that does have support for cloud attachments, which tells you that the standard doesn't, or probably doesn't, has a collection of reports and statistics and things like that. So I think both you, Doug, and Tom have had deeper dives into Microsoft's current stack. So just my notice is, what version are you on, and what is your service level? Are you a E1, E3, E5, or are you a Purview Standard or Purview Premium? You need to know where you are, and you need to have expertise in this area, as Martin Nickel, the illustrious expert in this, said.
Yeah, absolutely, Mary. Tom, do you want to comment on that? And then I certainly can add a couple of things.
Yeah, I think Mary hit it on the head. It's Microsoft is constantly upgrading things, and it's difficult to keep track of what's going on with Microsoft 365, the eDiscovery stack, and then the move into Purview, and what version do you have? And that's compounded, I think, by, especially with email. Microsoft mail systems are notoriously not backwards compatible with each other. So
Right.
you have to be really careful if you're, how far back is the mail going, and are you making sure you're getting something from each and every one of the mail archives that might exist. It's not something for the faint of heart.
That's a great way of putting it. Yeah, and I'll just add a couple of thoughts. Certainly, the fact that they were searching both Outlook and M365 is not surprising, because a lot of clients who are on M365 still have legacy data in Outlook. So you've got to search both places, and that's one of the challenges. And then, as Mary pointed out, there's files that aren't indexed. It's kind of a Purview, which is now Purview eDiscovery, are really kind of tied in together, and Purview seems to be the eDiscovery module, as well as the compliance and InfoGov module. Doesn't index certain files. Like files that are too large, or if they have too many attachments, there's limited file type support. So there's some of the challenges there that certainly you can run into.
I will add, the Microsoft attitude about this is use the Microsoft litigation hold to get things. Don't just go and collect things willy-nilly. That if you do use the Microsoft, the M365 litigation hold, the now Purview litigation hold module, it will go and find every one of the named custodians, tenants they call them. And it will find all the data that is associated with that tenant, even in web-based or cloud-based storage systems, or so they say. Obviously you need to test that, but it is their preferred method for making sure that you've gotten everything and indexed everything, is to use their litigation hold tool.
Yeah, absolutely.
So in fairness, I think just in fairness, we need to point that out.
Yeah, that's a great point. Absolutely. So Tom, obviously a ton of mistakes made here. So what lessons can we learn from all the mistakes that were made here by the defendant and their counsel?
Well, I think you said it. I think this comes off your blog post from the day you reported the case, that if any case illustrates the importance of having experienced eDiscovery / eDisclosure professionals involved in the subject, this one does. It's the project management, stupid. You talked about a white paper. I can't remember if you mentioned it at the onset of this or not, but you had one just within the last week that you put out on the site, right, Doug? On your site?
Correct. Yeah. It doesn't cover this particular disaster, but but there are plenty of disasters to choose from.
There's plenty of disasters to go around. But I think the point is, read up on project management. Our old friend Mike Guardarero, of course, wrote an entire book on it.
Right.
You got to have this kind of like the previous case where you have somebody has to be in charge of the different tasks in a complex litigation. When you're doing all of these sorts of things involving a big case, you got to have project management, whether that's somebody internally, whether that's an external vendor, whether that's a company or an individual consultant, but somebody has to be in charge of doing all this and using good project management standards and processes to do it. There's just too many moving parts to attack this or approach this in a willy-nilly fashion.
Yeah, great point. Somebody loves your comment. It's the project management, stupid. So there you go. And I always like to say, you got to have somebody driving the bus. If you don't, the bus ends up in a ditch. So
there you go.
That's kind of my way of putting it. Judge Peck, if this case happened in your court in the U.S., would you have ruled any differently, considering that Justice Smith also ruled that the defendant's failures were not deliberate?
No, although as I was thinking about this, I'm not even sure that 37E1 would apply, because the preamble, as we all know, is also a factor in 37E, and you got to show that information was lost. Well, here these missing or missed emails were not lost. They've now been recovered. So I think this might have been under a 37B for failure to obey court orders, if there was a court order about the production standards or whatever. But certainly, I think the result was fair. If you get to the 37E1, the prejudice was clearly shown, a 2-year plus delay in the trial, incredible costs, which presumably are costs that, are not just running interest, but are costs that wouldn't have been incurred if the trial went as it should have. But, so that would, under 37E1, give the cost and attorney's fees remedy that the judge did, but with no intent to deprive shown, and I don't disagree with Justice Smith, you wouldn't get to a 37E2. So whether under inherent authority, whether under a violation of one of the other parts of 37, not E, or however you get there, I think the result is correct and would have been the same in the United States, which just goes to, what Chris Dale, our friend, has been talking about for years, which is the parallels between British and U.S. discovery slash disclosure issues.
And this was a very fascinating case to read and talk about. And I do want to, I know we are at the top of the hour, a little past the top of the hour. I do want to address a couple of the comments / questions. One person said, I tuned into this presentation late. Please don't let that happen again. Just kidding. How do I obtain the slide deck? We will send out a link to the slide deck and also a link to the actual recording of the webinar, so you can catch what you missed. So absolutely. A comment, getting documents from a client when they are in email archiving can be a nightmare. I certainly can't argue with that. We've certainly seen, I've experienced that myself on a couple of projects, and it is a real challenge. And then I held off on this comment because we were past the case, but it is a very notable thing to bring up, where one of our viewers said, in addition to non-ESI, asking about industry-specific software is paramount. Finding out if any of these items are relevant is important. Asking to interview worker bees to see what programs they use is the suggestion. Examples: BIM, building information model, scheduling software, Primavera, drawing, Autodesk, Revit. For construction cases, many businesses also use specialized databases, i.e. CRM, and we actually did cover a case involving Salesforce data a month or two ago. So absolutely, very good point, and really appreciate that comment. So we do have a date for our next case law webinar, which is on Thursday, September 29th. Judge Peck's already found 3 cases for us to discuss for that one, so that gives us a big head start. So I will say thanks as always to Mary, Tom, and Judge Peck for their terrific insights, and I'll turn it back over to you, Mary.
Well, thank you, Doug. And please take a look again at the attachments tab for how to get in touch with Doug and Tom and Judge Peck. And after the end of the webinar, check at the top of the console for your certificate of attendance. There's also some links for you to register for the next case law, as well as our next webinars. And thank you, Doug. You always do a wonderful job anchoring. Thank you, Tom, and the Honorable Judge Peck for this insightful presentation. And our thanks to the EDRM community for your kind attention. Tune in next month for our case law for September on the EDRM Global Webinar channel. Thank you.
Thanks, everyone.
Thanks, everybody.
Thanks.